Add-on sentence for discharging gun from motor vehicle does not apply to shots fired while defendant was outside vehicle behind open car door. State of Ohio v. Michael T. Sweetis. Case number 2011-0244. 11th District Court of Appeals, Lake County.
Your defendant is between the car door, which is open, acting like a shield, and the car, but not in the car.
That is correct. Both his feet are on the ground.
And so don't we just really have a factual interpretation for a court as to whether that factual scenario, that the car is running and he is using the car as a shield, is sufficient to qualify factually? It would have been different if he had been on the outside of the doors just standing next to the car, but he's actually within that V using the car door as a shield, and why doesn't that just become a factual determination for the court?
Well, does it depend on whether the motor vehicle offers an advantage to the shooter as to whether or not it figures in the charge? Standing on top of a motor vehicle and shooting, yes, it may very well be that offered an advantage to the shooter,
yes,
to do so. I'm not sure in this situation whether that would be a fair test to say that the use of the vehicle in some way enhanced or allowed for the shooter to act in a way that would have enhanced what he was doing.
Isn't that what's happening here? There's a little overreach here with regard to what from means in the context of what everybody knows to be the drive-by shooting?
Your Honor, from means to indicate a starting point or focal point. And while I agree that it is commonly known as the drive-by specification, I have found nothing in the legislative history that would say that it was limited to drive-by shooting specification or drive-by shooting situations, and the cases that refer to it as a drive-by shooting. There is absolutely no analysis of legislative history or otherwise that indicates that, in fact, it is limited to those situations.
On October 11, 2012, the Supreme Court of Ohio held that a provision of state law that adds 5 years to the prison term of a defendant found guilty of discharging a firearm from a motor vehicle during the commission of a felony does not apply to a Lake County defendant who fired shots at 2 men while he was standing next to his vehicle behind an open car door. The court's 7-0 decision, authored by Justice Paul E. Pfeiffer, reversed a ruling by the 11th District Court of Appeals that found that the statutory language of Revised Code 2941.146A was not limited to shots fired within or while riding in a motor vehicle when considering whether the firearm had been discharged from a motor vehicle.